Website accessibility, ADA compliance, and what actually leads to lawsuits is still very much a mystery to most website owners. So we're going to go through a complaint that was filed in New York federal court. And this complaint was filed on September 5th, 2024, so just 1 week ago. We're going to go through this complaint, and I'm going to explain what leads to lawsuits and how to significantly reduce your risk of being sued. So on the screen with me is the complaint. The plaintiff is Juan Igartua. The defendant is Recreational Plus, a cannabis company, and this complaint was filed as a class action. Now, that is alarming to many people when they hear that they have a class action complaint filed against them, but just know that this is quite common, and plaintiffs' lawyers may use the class action to attempt to negotiate a higher settlement amount, but just know that this isn't as alarming as it may seem. Now, continuing down, we have an introduction where we get the background for the plaintiff and the defendant. And here, the background for the plaintiff reads, plaintiff is a visually impaired and legally blind person who requires screen reading software to read website content while using his computer. And this is very common. Almost all of these cases involve a plaintiff who is blind or visually impaired. So just know that, sometimes there will be a plaintiff with other disabilities, but usually it is the case that the plaintiff has a visual impairment. Now, the defendant here is Recreational Plus. This is a cannabis company, and we have seen the cannabis industry significantly impacted by website accessibility litigation. So, of course, there are many different industries that have been targeted, but among those, the cannabis industry has been targeted with some frequency. And so here we see the website for the defendant is recreationalplusnyc.com. But when I go to the website using the link in the complaint, we go to actually another cannabis store in New York City. So this one is Trends LIC. So what is likely the case here is that the plaintiff's law firm sued Trends LIC, but they did not change out the hyperlink. So we do have the text that has changed, but the underlying link is likely the same. So that's one notable from this complaint. And then we get into a bunch of background information. And so, here we have a Census Bureau report stating how many different individuals in the United States have a visual impairment. There's a paragraph 5 about congressional action and on and on. And then we have jurisdiction and venue. And I'm not going to get into all of these different sections, but what I do want to read through are some of the parts on accessibility issues. So we have reference here to the Web Content Accessibility Guidelines. And then in paragraph 21, we have non-compliant websites pose common access barriers to blind and visually impaired persons. Common barriers encountered by blind and visually impaired persons include, but are not limited to, the following. And then we have a long list of accessibility considerations from A through Q. So these aren't the actual accessibility issues being alleged that exist on the website. These are just really background here for what accessibility issues may be. And then we have a section on standing where the plaintiff's lawyer attempts to establish standing for the plaintiff. And then we'll continue on down. In paragraph 28, we get to the actual facts behind this complaint. And here's where the accessibility issues start to come up. So it says plaintiff discovered defendant's website around August 23rd as a result of a recommendation. In paragraph 30, we have the website contains thousands of products. It sets up paragraph 31, which states that however, a link without an accessible name can significantly impact the blind user who relies on a screen reader. If a link lacks an accessible name, the screen reader may not be able to provide meaningful information about the link's function or destination. So this is getting at anchor text links. Here we have the first accessibility issue being alleged. Continuing on with paragraph 32, it says, for instance, as stated, plaintiff sought information about their edible, and then it names the product. In paragraph 33, it says, however, when attempting to discover crucial medical information about this product and others with similar properties, plaintiff was unable to discern any further information other than what was contained within the product tile as a result of quote unquote suspicious alternative text, quote unquote linked images missing alternative text, and quote unquote empty buttons. So here we have tangible accessibility issues that are being claimed by the plaintiff. We definitely want to make sure that we have taken care of all of these issues. But let's continue on because we get a little more information behind the issues. We have paragraph 34. Moreover, this specific webpage provides a description of the product. However, this written statement as of the time of access lacked quote unquote alternative text and thus incomprehensible to plaintiff and other sight impaired individuals. See Exhibit B. Because I looked at the filings with this complaint, I know that Exhibit B involves reports of scans, and we will talk about that in a moment. In 35, we really have the quick summary of what's happening here. As a result of visiting defendant's website from his home, plaintiff is aware that significant portions of the website are unusable due to various barriers that deny him full and equal access to defendant's online products and services. All right, so there we have the endpoint. This is what everything leads to. is allegedly the plaintiff has been denied full and equal access. In paragraph 36, we have on August 30th, 2024, plaintiff's counsel conducted accessibility audits of the website to corroborate the existence of those barriers which prevented plaintiff from conducting a search for desired products, etc. Specifically, plaintiff's counsel conducted accessibility audits using the WAVE evaluation tool or the WAVE Web Accessibility Evaluation Tool. This program confirmed the presence of multiple violations of the ADA as reflected within the completion of said audits. See Exhibit B, WAVE report, dated August 30th. All right, so here, one thing to note, there are not, just because WAVE flags an accessibility issue or names an error does not mean there has been a violation of the ADA. And it states here in the complaint, this program confirmed the presence of multiple violations of the ADA. The legal standard under the ADA for Title III entities is meaningful access. So just because there's an accessibility issue does not mean meaningful access has been denied. What this is getting at is there are accessibility issues that are being flagged by an automated scan. Scans aren't dispositive, they aren't conclusive. Even of the issues that are flagged, we still need to look at those issues and really uncover whether or not the issues exist, whether those issues actually amounted to a barrier to access, or a significant degradation in experience. One other point here is that these aren't audits; these are just scans. You can go use WaveScan right now for free. It takes a matter of seconds to scan a page on your website and look at the accessibility issues being returned. So these are not audits. Audits are completely different. An audit is going to be a thorough manual evaluation of a website. A scan is not an audit by any means. But for the purposes of this complaint, it nevertheless did flag accessibility issues which were named in this complaint and alleged against really here the defendant's website. One note here is that you always want to have 0 errors returned on a scan. That is always best practice. But note that the accessibility issues claim often go well beyond scans. So some plaintiffs' lawyers still do rely upon scans, but many others have evolved and they have upped their game. So it was the case that several years ago that all it took was really just to have 0 issues showing on WAVE or any of the other popular scans, and you were good because that's where plaintiffs' lawyers stopped. But now they have upped their game. Some plaintiffs' lawyers have actually recruited accessibility professionals to find accessibility issues for them. I know this firsthand because I was recruited by a plaintiff's law firm. So I know that plaintiffs' law firms sometimes have accessibility professionals that are working to find accessibility issues. If that's the case, they are not simply using a scan, but it is always best practice to not have any issues showing up on a scan. So that's really a good starting point, but it's definitely not an end point. And here we have this plaintiff's law firm that is relying upon scans. We do see that they have used the WAVE scan. And as I said, I know that they used another scan, which is named SortSite, because it was a part of their attachments with the filing. So SortSite is better known as PowerMapper, and this is a paid scan. The difference between these two scans is that really PowerMapper gets more granular. WAVE is what I recommend because it is intuitive, it is easy to use, it educates you as you are going through it. So WAVE is also the most popular scan, but they used PowerMapper as well. So they have 2 different reports from scans. And that's what they're using here. They say this is corroborating what the plaintiff experienced, and that is what they're using here to really serve as the basis, or at least a partial basis, for this complaint, if nothing else, saying that it backed up what the plaintiff encountered. Due to the aforementioned and many other access barriers which prevented plaintiff from discerning crucial information about the desired goods and services, plaintiff was unable to complete his search and purchase those desired products and services. So again, this gets at the endpoint. So even in the previous paragraph, we heard about suspicious alt text and empty buttons amongst numerous other barriers. And then here in paragraph 37, plaintiff, it says, due to the aforementioned and many other access barriers. So there's really a catch-all here for the plaintiff's law firm that they are incorporating into the complaint. So it's just to say it's not only these issues, there's many more that we can name off if we need to. But here we did see 3, I think there was 3 accessibility issues named. So suspicious alt text, empty buttons, and what was the other one? It was linked text, I believe, but it says linked images missing alternative text, suspicious alternative text. Linked text is the actual wording they used. But regardless, we have accessibility issues that are specifically named. The level of detail here isn't as specific because it doesn't actually say, in some ways we have some specificity, but in other ways it's not clear to me exactly where this issue would be or how it came about. But regardless, these are accessibility issues that you would want to pay close attention to. And by the way, alternative text and issues that result from any alternative text issues are the single most commonly claimed issue these lawsuits. So where I would start is absolutely alternative text. You definitely want to make sure that any meaningful images contain alternative text, and any decorative images or images that don't really have any meaning or it's nominal meaning, then you would mark those as decorative by leaving the alt attribute empty. But that is just one accessibility issue. It is the issue that is most commonly claimed, but it is only one issue of many. So we saw here empty buttons, suspicious alternative text, lacking alternative text, and then what was the other one again? So we want to make sure that all of those issues are taken care of. Now, in my ADA compliance course, I go over the 15 most commonly claimed accessibility issues and tell you how exactly to prioritize them, or what exact order to prioritize them, and then how exactly to find and fix each of these issues. So it's very, very important that you take care of the issues that are claimed the most often. And by the way, I know we're focusing in on this complaint, but this is just one complaint filed by one plaintiff's law firm. And by the way, this plaintiff's law firm is Joseph and Norinsberg, LLC. So the signing lawyer here is John L. Norinsberg. But this is just one plaintiff's law firm, and there are literally dozens of these plaintiff's law firms. By my count, there are over 40 of these plaintiff's law firms who are very active to fairly active to moderately active. But the good thing is they recycle through the same accessibility issues over and over again. So you need to pay attention to those accessibility issues that come up the most frequently. And there are 15 issues that are by far the most commonly claimed accessibility issues. So you've heard about the Web Content Accessibility Guidelines, and this complaint actually references the Web Content Accessibility Guidelines. Now, being fully WCAG 2.1 AA conformant is a best practice for preventing any of these types of lawsuits. But what you need to know is that there are 50 accessibility considerations or things to account for or resolve on your website for WCAG 2.1 AA conformance. So my point here is that it does take a while to get through. So you want to prioritize certain accessibility issues that are most likely to lead to a lawsuit, because that is going to be what significantly reduces your risk. So the way in which you approach WCAG conformance very much matters, because this website accessibility is a project, and it can take a few months or it can take several months. So if you are working on accessibility, there's no reason not to start with the issues that are most likely to be claimed in a complaint filed in court. So you want to take care of those issues first. And I have just scrolled up to paragraph 20. And here we have the mention of WCAG, WCAG 2.1, and it's the Web Content Accessibility Guidelines. This is from the World Wide Web Consortium, and here we have this mention in paragraph 20. So it says these guidelines are universally followed by most large business entities and government agencies to ensure websites are accessible. And what you need to know is that plaintiffs' law firms use the Web Content Accessibility Guidelines to really work from accessibility issues from there. And sometimes they'll claim issues that aren't actually even in WCAG at the conformance level of AA. So just know that. And here we don't even have the conformance level mentioned. It's just WCAG 2.1. So this could even open the door to a plaintiff's law firm going into AAA conformance, which is not universally relied upon. But these are the accessibility standards that are commonly referenced, and we want to be, the best practice is to be fully conformant. But again, we want to prioritize the issues because certain issues are just more likely to lead to lawsuits than others. And of course, we also want to have zero errors on a scan, because many of the issues flagged by a scan end up being claimed by plaintiffs' lawyers, but just know that there are more issues that they look for. So a scan is a good start. We always want to have zero issues, but whether you're using Google Lighthouse, a sort site, a Power Mapper, whether it's Wave, whether it's Axe, it does not matter. Accessibility scans can only flag so many issues. So we need to make sure that our website is fully accessible as much as, we need to start with the issues that plaintiffs' lawyers look for. And in here, we came across 3 or 4 issues that were named. So we definitely want to make sure that we take care of those. And then, by the way, the laws here that are cited, that the laws that are alleged that are being violated include the Americans with Disabilities Act. And then we have local laws. So we have the New York City Human Rights Law, the New York State Human Rights Law, and then we have the New York State Civil Rights. So we've gone through this complaint. And now this is very typical. It's not, these complaints vary. There are going to be different levels of specificity, different accessibility issues being claimed, different laws being alleged that are being violated. But this is what we typically see from these complaints filed in court. And then, of course, demand letters are also a part of this. And demand letters will have usually less specificity, and they definitely won't go into all this detail. But this gives you a really good feel for what actually leads to lawsuits. So now you just need to understand what the accessibility issues are that are most commonly claimed, what the technical aspects of those issues are, and then how to find them and how to fix them. And that's what my ADA compliance course gets into. The ADA compliance course explains exactly what you need to prioritize and how to find and fix each issue. And this can be for website owners, but website owners are typically going to be reliant upon their digital accessibility team, or not their team that works on their digital operations, so their social media, their website, etc., their mobile app. When you have the course, you can give the course to your team as a set of instructions. You will need someone with a web development background. So this may involve hiring a freelancer. And this is not the perfect approach, because the perfect approach is an audit and remediation and full WCAG conformance, but it is a fast approach and it gets you started immediately so you can start reducing your risk right now and work through the most commonly claimed issues so that it's much less likely that you are targeted in litigation, because what you're doing is you're taking the accessibility issues that plaintiffs' lawyers look for and you're just resolving those. So there's really nothing to go on for the plaintiffs' lawyers. And so then after you complete the course, you go through and you work through full WCAG conformance. But as I said, there's a lot to get through. So you want to start with the most commonly claimed issues. And the ADA compliance course is going to tell you everything you need to know and exactly where to get started. And as I was getting at, it really is like a set of instructions that you can give your web developer. And of course, your web developer doesn't have accessibility expertise. This is something that they're going to be learning, but it is a way to get started fast. It is a way to be aggressive, and it is a way to gain more confidence and a sense of relief knowing that you are remediating or fixing those accessibility issues that are most likely to lead to a lawsuit. So I recommend you start here and then you continue on with full WCAG conformance. I will link to the ADA compliance course in the description along with accessible.org services. So in case you want to work on an audit, so where we find all of the accessibility issues and then you can fix the accessibility issues found in the audit and or hire us for remediation. But I recommend either way that you get started as soon as possible, because there are many plaintiffs' lawyers involved and many of them are actively involved in website accessibility litigation. So I highly recommend my course. It is the ADA compliance course, and I will link to it in the description.